Our fight for our rights under the Second Amendment just took a critical turn. Illinois is under fire for forcing people to jump through pointless bureaucratic hoops just to own a firearm. There's a fundamental issue at stake. Does the state have any business demanding fees and paperwork before letting us exercise our right to keep and bear arms? In this video, we're diving into a major Second Amendment lawsuit targeting Illinois' firearm owner identification, or FOID law. We're going to break down the major arguments, the stakes for all of us, and the serious possibility that this case could reshape firearm ownership across the entire country. If you value your 2A freedoms like I do, trust me, this is an issue you can't ignore. Let's start by spelling out what FOID means. In Illinois, before you can legally possess a firearm, even in your own home, you've got to get one of these FOID cards. It's not a casual formality either. There's a whole process involved. An application, a fee, background checks, a wait, etc. Pure bureaucracy, if you ask me. That alone is already a big problem. Unlike concealed carry permits, which regulate carrying guns in public, this FOID scheme demands government approval just to keep a gun you never planned to take outside. That's an important distinction. Sure, the average American might be more familiar with debates over carrying firearms in public, but it's a whole different scenario when a state tries to license you just for owning a firearm and keeping it somewhere in your own property. This FOID law is exactly that. And it goes against the very core of the term keep in the right to keep and bear arms. And it gets worse. The FOID's impact isn't limited to Illinois. If the state can get away with this kind of regulation, you can bet other states are going to try something similar. Even though shall issue concealed carry permits are basically standard in most places, Illinois demands licensing for mere possession. That's not progressive, that's oppressive. They're not just making it harder to carry. They're making it harder to simply own a gun in your own home. This is what the Gun Save Life versus RAL lawsuit is all about. It asks a straightforward question. Can a state override what should be a fundamental right that we hold without special government permission? The Supreme Court took a big step toward clarifying these rights in 2022 with the New York State Rifle and Pistol Association versus Bruin decision. That landmark ruling knocked out New York's restrictive may-issue licensing for concealed carry, reaffirming that the right to bear arms is exactly that, a right, not a privilege. However, Bruin's footnote 9 introduced a bit of confusion. The court hinted that shall issue permitting might be okay, but it really didn't talk about laws covering mere possession. That brings us to the main players. Gun Save Life is a staunch 2A advocacy group that says the FOID law creates unconstitutional hurdles for responsible, law-abiding folks like us. According to them, forcing us to get a government license just to possess a firearm breaks with the very principles of the Second Amendment. The state of Illinois, of course, claims the FOID requirement is critical for public safety. They say it's a way to ensure responsible gun ownership. Yeah, responsible gun ownership, my butt. The text of the Second Amendment is as clear as day. The right of the people to keep and bear arms shall not be infringed. And yet, Illinois' FOID law tries to skate right past that clarity by insisting that the state can impose fees, license applications, and waiting periods on something that should be guaranteed. The distinction between keep and bear matters here. The Second Amendment protects two separate but equally crucial aspects of our right to arms. Keep is about possession. Bear is about carrying arms in public. While Bruin dealt more directly with bearing arms, this case is all about the keep portion, especially inside our own homes, where our right to be left alone with our legally owned firearms should be absolute. When we say shall not be infringed, we mean no government barriers. Historically, infringe means to hinder, restrain, or obstruct, even slightly. So if I have to jump through multiple bureaucratic hoops, pay a fee, and get the government's green light before I can possess a firearm, that's an obstruction. That's turning our right into a privilege, which is absolutely not how the Constitution intended it. Bruin sets up a framework. Any gun regulation today must have roots in historical tradition as it existed at the time of the founding. This flips the usual burden. It's the government's job to prove that a law like FOID aligns with long-established practices. And as far as I can tell, there's no historical precedent for a license requirement just to possess a firearm. Nothing in the 18th century required that. There's certainly nothing in the Bill of Rights that suggests it either. Illinois' FOID law sticks out as a glaring anomaly. All this analysis frames a bigger question. Can the state justify such a huge infringement on a fundamental right? Looking at the historical record, the answer seems to be no. But the arguments don't stop. We dig deeper. Do these requirements actually support the broader purpose of the Second Amendment? I'd argue they do the exact opposite. They undermine it by implying the government can ration out the ability to own a firearm. On one side, Gun Save Life says the FOID law is a prime example of overreach. Since keep covers possession and the state demands an application, a fee, and official approval, Illinois is effectively treating the right to possess a firearm like a regulated privilege. Pro 2. A advocates like me say this hits law-abiding folks the hardest. We're the ones who follow rules. We're the ones who will jump through the hoops. Meanwhile, criminals couldn't care less about FOID. They'll get guns any way they want, effectively ignoring the law or forging documents. So who's really being harmed here? The state fires back that the FOID law is a simple measure. Pay a nominal fee, fill out a form, and if you're not a prohibited person, you'll get your license. They frame it as a screening tool to keep guns away from felons or folks with mental health problems. They also claim the law doesn't directly violate the Second Amendment because it only places a small hurdle in front of gun ownership, not an outright ban. They say it's more about regulating access than denying a right. But Gun Save Life says that even a small hurdle can become a big infringement. The Supreme Court, especially after Bruin, requires that restrictions on firearms have clear historical equivalence. The FOID law just doesn't pass that test. Plus, we already have federal laws under 18 U.S.C. 922G forbidding certain people, like felons or those under restraining orders, from possessing firearms. So why do we need an extra state-level licensing scheme? It only adds bureaucratic layers for law-abiding citizens who weren't a danger to begin with. That's my beef with the FOID law. It penalizes responsible gun owners who are just trying to follow the rules. Meanwhile, criminals will ignore these rules anyway, making the law look ineffective at best and tyrannical at worst. This kind of approach also sets a dangerous precedent. If the government can license one constitutional right, what's to stop it from licensing others? Do we need a license to exercise free speech next? It's a slippery slope, and I'm not willing to go down that path. Now, let's talk about the Bruin decision's broader impact. The 2022 ruling in New York State Rifle and Pistol Association v. Bruin really changed the game by clarifying that all firearm regulations must be consistent with this nation's historical traditions. New York's May issue law was struck down because it allowed government officials to arbitrarily deny concealed carry permits. The Supreme Court made it clear, the Second Amendment is not a privilege that bureaucrats can dispense at will, but Bruin tackled public carry. It didn't address whether states can force you to get a license just to own a gun at home. Footnote 9 in Bruin vaguely suggested that shall-issue systems might be fine, but Illinois' FOID law isn't about carrying, it's about basic possession. That's a significant gap. It puts FOID in direct conflict with the keep part of the Second Amendment by pointing out that possession licensing is historically and constitutionally suspect. Gun Save Life versus RAL questions whether Illinois can require a FOID card at all. This case doesn't just refine Bruin, it tests how far that decision can actually go. If the courts apply Bruin's historical tradition test rigorously, I'd argue there's little chance FOID survives. There's simply no historical practice of demanding a license to possess firearms in your own home. That's why Gun Save Life versus RAL matters so much. A ruling against FOID could invalidate similar laws in other states. That would send a powerful message. If you want to regulate firearms, you better have historical precedent for it, and you better not infringe on the everyday American's right to keep a gun at home. Of course, if Illinois somehow prevails, anti-gun states might be encouraged to create more draconian requirements for mere possession. We'd be stuck with a jigsaw of inconsistent state laws, some drastically restricting an unconditional right. That's a worst-case scenario in our book, because you'd have Second Amendment-friendly states where it's easy to keep a firearm legally, and then places like Illinois or New York doubling down on licensure, fees, and hoops you have to jump through. Legally, this could escalate right up to the Illinois Supreme Court, which has a reputation for not exactly being friendly to conservative or pro-Second Amendment perspectives. If the state's highest court sides with FOID, this might head to the U.S. Supreme Court. That's the big stage where a definitive ruling could settle the matter across the nation, and the stakes couldn't be higher for gun rights. A victory for Gun Save Life would not only dismantle the FOID system in Illinois, but also reaffirm a consistent, nationwide standard for how we interpret the Second Amendment. A defeat could embolden anti-gun lawmakers elsewhere. They'd try to license every aspect of firearm ownership, turning a right into a labyrinth of forms and fees. Personally, while I have no crystal ball, I'm optimistic. After Bruin, courts have less room to uphold arbitrary gun restrictions. But if you think this is a done deal, think again. There's still legal wrangling ahead. Whether FOID stands or falls, the decision will resonate far beyond Illinois' borders. It'll shape the legal strategies for future battles over what laws we can constitutionally impose on gun owners. Let's also address the glaring inefficiencies of the FOID law. Criminals don't care about it. They're not waiting in line for a license. They'll acquire guns illegally, ignoring whatever form the state requires. So the law ends up punishing me, someone who abides by rules. That's our core problem with FOID. It does zero to stop people who already break the law, but it makes you and me pay fees, fill out applications, and possibly wait weeks or months just for the privilege of owning what the Second Amendment guarantees we can have. Moreover, there are already federal laws like 18 U.S.C. 922, banning felons, domestic abusers, and others from possessing firearms. If Illinois is serious about keeping guns out of the wrong hands, maybe enforcing existing laws would be a better strategy than piling on new regulations that only trip up honest citizens. The defense says the FOID process is no big deal, just a minor inconvenience. But even minor inconveniences can turn into major infringements. If you can't exercise a right without paying fees or completing a tedious process, is it really a right at all? Historically, an infringement was anything that even slightly hindered or obstructed the enjoyment of a right. That's what FOID does, and we can't ignore the broader legal climate in Illinois. The Illinois Supreme Court isn't exactly known for championing conservative or 2A values, so even if Gun Save Life wins at an appellate level, the road ahead is not guaranteed to be smooth. The higher courts could still reverse or undermine that victory. That's why I'm keeping a close eye on the entire process. It's not enough to win once. We need a final say from a court that sets a binding precedent. All the criticisms of FOID point to a bigger problem, the tension between individual rights and the state's desire to regulate. The Second Amendment provides a blanket protection for law-abiding people to own firearms without arbitrary red tape. Illinois' FOID law embodies the opposite principle, that you must ask permission from the state. That undermines the essence of the Constitution and sets a harmful example for other jurisdictions to follow. So we're left with a fundamental question: will Illinois' FOID law, or any similar law, hold up under the historical scrutiny that Bruin demands? I don't think so. I think this will be a watershed moment for Second Amendment rights. But if it somehow does, then anti-2A states might ramp up their licensing demands, driving an even bigger wedge between jurisdictions with high respect for the Constitution and those that see it as a pesky roadblock. We'll see how the courts rule and whether this law can survive a proper application of the Bruin framework. Hopefully, our liberty and constitutional text prevail over bureaucratic overreach. If they do, Illinois' FOID law will be history, and other states might think twice before adopting similarly restrictive schemes. If they don't, we'll have a bigger fight on our hands, one that could redefine how we exercise our Second Amendment rights for decades to come. But that's it for now. If you like what we do here, please like, share this video with your Pro2A friends, subscribe to our channel, and click on that notification bell to get an update on this lawsuit. Thanks for watching.